we see that the Shinde camp now, in their claims through that petition, says the Shinde camp saying that this is a violation of natural justice. This, of course, the Shinde Sena saying violation of natural justice, considering he has the numbers, the two-third majority. In that eventuality, there is no way that the Uddhav Thackeray camp can appoint a chief whip or use the deputy speaker to disqualify members, because they don't have the strength. Even to appoint a chief whip, Ajay Chaudhary, who's been appointed, to appoint a chief whip, one needs the two-third majority to sign on a paper or document to approve the chief whip's appointment. But none of that happened. It was not. There was no due process that was followed by the Shiv Sena. Ajay Chaudhary was, according to the Shinde Sena, arbitrarily appointed as the chief whip, and the chief whip issued a whip to all those MLAs: if you don't appear for the meeting at Varsha, the Chief Minister's residence, a few days ago, then they would face disqualification. So on all grounds, this is illegal and this is a violation of natural justice. This is exactly what the Shinde Sena says. Gaurav, almost quite a emotional appeal that the Shinde Sena is making, that despite having the two-third majority at this point, it doesn't seem like they have received natural justice. They call this illegal. All the process that Uddhav Thackeray has followed, right from using the deputy speaker to initiate disqualification proceedings and appointing a chief whip without having the numbers, all illegal and defies natural justice for the Shinde camp.
So, principles of natural justice not being followed is the contention of the Eknath Shinde Sena with regard to the timing of the disqualification notice or the time given to respond to the disqualification notice. As far as numbers are concerned, you're absolutely right. They've claimed they have the numbers. They claim they have the support of 38 Shiv Sena MLAs. But and this can only be proven on the floor of the House. But principles of natural justice not being followed. One, a notice issued by Deputy Speaker when a vote when the two MLAs had already said they had no confidence in the impartiality of the Deputy Speaker. So that's a violation of principles of natural justice, and the timing given to respond only till 5 p.m. today is a violation of principles of natural justice, where the time given should be at least 14 days as per norm. So these are the two aspects that are being raised by the Eknath Shinde Sena in the Supreme Court. It remains to be seen what the Supreme Court does on these petitions, but past precedence is something again that the Shinde Sena is relying on in Supreme Court by saying that principles of natural justice are not being followed by the Deputy Speaker in responding to the queries or the points that have been raised by the Eknath Shinde Sena MLAs, 16 of them who received disqualification notice.
Right, you know, Gaurav, in that matter, if principles of natural justice were to be followed, then the first things first, the Deputy Speaker should have approved the no confidence motion against himself. Is that the first step?
That is the contention. But the point is, the moment, since all sides are consulting their best legals and legal minds, their point was the moment there is a vote of no confidence, the moment there is a plea of no confidence against the Deputy Speaker, he cannot take a decision on the disqualification of 16 Shiv Sena MLAs as sought by the Shiv Sena party. Point one. Point two, his recognition of Ajay Chaudhary as leader of the Shiv Sena legislature party. Again, the Eknath Shinde Sena says, how can a minority group in the party decide who the leader would be when the majority group has unanimously, which is 38 MLAs have unanimously decided it would be Eknath Shinde. So these are points where they say that again with the whip of the party, how can the minority group decide what will be the whip? It's only 16 MLAs on one side with Uddhav Thackeray, majority 38 on the other side. So these are points that have been raised. And now it is for the Supreme Court to decide finally, who is with the truth here.
You know, Nalini, if you are with me, in fact, just yesterday we saw that the Shiv Sena roped in Supreme Court lawyer Devdutt Kamath to give out a formal message to the media. Through the media, in fact, they reached out to the rebel camp, almost warning the rebel camp that this two-third majority that you are harping upon right from day one makes no sense and has absolutely no validity until unless you merge with another party. So, in your legal perspective in view here, will the two-third majority hold good for the Shinde Sena camp at this point to in fact carry forward with their appeal to the Supreme Court. What does Devdutt Kamath means when he says that two-third majority holds no good unless you merge with another party?
Well, Nabila, what's interesting, and it's good that you asked me this question because it's important to clarify this. 10 schedule specifically states that this two-third majority that the Shinde camp is claiming comes only into the picture when this camp or this two-third majority splits away from one party and joins or merges with another party. This merger with another party in this case has not happened. They have only split away from the Uddhav Thackeray led Shiv Sena, which means that there are now two separate factions of the Shiv Sena, and this newly formed faction, the Eknath Shinde faction, has not merged with any other party for the 10th schedule proceedings to be attracted in this case. That's what Devdutt Kamath was speaking about. But what's even more interesting about this is that because both these factions, the Eknath Shinde faction as well as the Uddhav faction, have been seeking legal opinion from the very first day when the rebels actually broke away from the faction and first moved to Surat and then moved to Guwahati, because they've been seeking legal opinion every step of the way, it is extremely possible that even if the Eknath Shinde faction merges with another party, then that merger itself may be in question before a court of law. And the reason why that's interesting is because that will be the first time ever where the Supreme Court will decide on this issue of a two-thirds party merging with another party. This is an issue that has never come before the Supreme Court, and there is no judgment of the Supreme Court on this entire matter. So it'll be the first time that the Supreme Court will be passing an order on this particular legal aspect. So in terms of that, this case can very well go ahead and become an unprecedented case when it comes to either disqualification proceedings or the falling of a government in a particular state. Each and every aspect, because it's being put in challenge before a court of law, as it's been done by the Shinde faction before the Supreme Court, we can expect that even if this merger happens, it will be subject to judicial proceedings and the final order of the Supreme Court.